You paid cash for a used car. The title looked clean. The seller shook your hand.
3 months later, a tow truck appeared at your job. A lender you'd never met held a court order. They took the car, and under federal law, they had every right to do it. This isn't a scam. This is Article 9 of the Uniform Commercial Code, the federal framework that governs secured transactions in every U.S. state. And if you don't know how it works, your driveway is never truly yours. Richard Feliz thought he had done everything right. In 2017, he walked into an Illinois dealership and bought a 2011 Porsche Panamera for $59,000. The dealership showed him a state-issued certificate of title. No liens were listed. No warnings appeared. What Feliz didn't know was that the original borrower had submitted a fraudulent lien release letter to the Illinois Secretary of State, obtained a duplicate title that erased BMW Financial Services' perfected security interest, and sold the vehicle into the retail stream. When the original borrower defaulted on the loan, BMW located the Porsche.
They filed a repossession action, a lawsuit to recover specific property. The Illinois Appellate Court ruled that a duplicate title does not extinguish a perfected lien. The word duplicate implies the original title's legal force remains intact. BMW kept the car. Feliz kept the loss. His $59,000 bought him a legal education he never wanted. The used car market runs on trust. The law runs on paperwork. They are not the same currency. Feliz lost his car because of a single legal concept called perfection. When a bank finances a vehicle purchase, it creates a security interest, a legal claim that makes the automobile collateral for the loan. To protect that claim against future buyers, the lender perfects it, typically by having its lien noted on the official state certificate of title. Most Americans believe that a clean title means a clean car. It doesn't. A certificate of title is evidentiary. It is not absolute proof of clear ownership. In Feliz's case, the Illinois Secretary of State had issued a duplicate certificate that omitted BMW's lien. The dealership verified computer records. They saw no liens. They sold the car in good faith. The court still ruled for BMW because BMW never executed a legitimate lien release. Its perfected security interest maintained priority over both the dealership and Feliz. The paper was wrong. The law didn't care. This rule isn't unique to Illinois. UCC Article 9 governs secured transactions in every U.S. jurisdiction. Section 9 to 315 is the legal mechanism that makes these repossessions possible. It states that a security interest continues in collateral, notwithstanding its sale, lease, license, or other disposition. The lien follows the vehicle, not the person. If the original owner sells the car without satisfying the outstanding loan balance, the lender's claim attaches to the metal itself. Your good faith as a buyer doesn't matter. Your full cash payment doesn't matter. What matters is whether the secured creditor formally released its interest. In 1997, a New York buyer named Green learned this after purchasing a used vehicle from a retail dealer. The dealer never possessed the physical certificate of title because Arcadia Financial held it as collateral for an unsatisfied loan. When the dealer became insolvent, Arcadia repossessed the car from Green's driveway. The New York Supreme Court dismissed Green's action against the lender. The judge wrote that the legal burden rests squarely upon the purchaser to verify title authenticity and demand delivery of the actual certificate before completing the transaction. Arcadia's perfected interest, noted on the retained title, was superior. Green absorbed the loss. Sometimes the buyer wins, but only when the state itself makes the mistake. In 2005, the Georgia Court of Appeals heard a case that flipped the script. AmeriCredit had financed a vehicle in New York and perfected its lien on the New York title.
The borrower relocated to Georgia and applied for an out-of-state title conversion. A Georgia DMV clerk made a data entry error. The newly issued Georgia title failed to reflect AmeriCredit's perfected lien. The vehicle sold through multiple intermediaries to Teresa Metzger, who purchased it in good faith with a clean Georgia title in her hand. When AmeriCredit located the car, they repossessed it from Metzger's home. She sued for conversion. The Court of Appeals reversed the trial court and ruled for Metzger. Under UCC Section 9-337, when a state titling authority issues a certificate that omits an existing perfected security interest due to administrative error, a good faith purchaser who pays value and takes delivery without notice takes the property free of that interest. The court declared AmeriCredit's repossession unlawful. The lender's remedy lay against the original debtor, not the innocent buyer. But notice the standard. Metzger won because she had no actual, constructive, or inquiry notice. If she had suspected something was wrong and bought anyway, the outcome would have been different. But the part almost nobody knows is still coming. Because even if you dodge the bank, you might still owe the mechanic or the toll authority. And those debts can lock your car in a garage or block your license plates entirely. Beyond bank financing, vehicles carry non-consensual liens created by state statutory law. When a repair shop fixes a car and the owner refuses to pay, the shop gains a mechanic's lien. Unlike a bank's Article 9 interest, which requires public recording or title notation for perfection, a mechanic's lien relies on continuous physical possession of the vehicle. In many jurisdictions, these liens possess super priority status, elevating them above previously perfected bank loans and subsequent purchasers. If a seller abandons a vehicle at a shop, fails to pay the bill, and later sells you the car without settling the debt, the shop retains the right to hold the vehicle. They can execute a statutory foreclosure sale, transferring clear title to a new buyer and extinguishing your rights entirely. Then there are municipal registration holds. Unpaid parking citations, automated red light camera fines, and toll evasion penalties don't always vanish when the car changes hands. Under statutory frameworks like California Vehicle Code Sections 4760 and 40220, state departments of motor vehicles can block registration renewal for a vehicle with outstanding violations tied to its VIN. You might buy a car, register it successfully, and discover 6 months later that the state refuses to issue new license plates until someone pays the previous owner's $800 in toll fines. That someone becomes you. You are not being sued for the debt. Your ability to legally operate the vehicle is simply blocked until the underlying obligation is satisfied. The system has other cracks that don't involve debt at all. Title washing occurs when damaged vehicles move between states with different branding laws. A car declared total loss or flood damaged in one state gets retitled in another jurisdiction with weaker statutory definitions, and the damage brand disappears from the paper. Experian automotive data indicates that more than 15% of damaged vehicles lose their brands during interstate transfers. The National Motor Vehicle Title Information System, or NMVTIS, was designed to stop this. Congress created it under the Anti-Car Theft Act of 1992. Operated by the American Association of Motor Vehicle Administrators under Department of Justice oversight, NMVTIS enables state titling agencies and consumers to verify title histories, brandings, and theft data across all 51 U.S. titling jurisdictions. Yet buyers still skip the check. They trust the paper in their hand. And that trust costs them. The Department of Justice estimates that vehicle theft and title fraud carry a combined annual economic cost of roughly $8 billion. Some of that loss lands on buyers who thought a certificate of title was a guarantee of clear ownership. It was never meant to be. The law does not treat used car buyers as innocents by default. The baseline rule remains caveat emptor. Let the buyer beware. In private party sales, unless the seller commits fraudulent misrepresentation, the buyer assumes the risk of defects in both physical condition and legal title quality. UCC Section 2-312 does create an implied warranty of title in every vehicle sales contract, promising that the title conveyed is good and free from undisclosed security interests. But this warranty only gives you a civil lawsuit against the seller for breach of contract. It does not stop the tow truck. It does not unlock the registration hold. If the seller is insolvent, fraudulent, or untraceable, the warranty becomes a piece of paper worth exactly nothing, while the lender drives your car away. The statutory safe harbors are narrow. UCC Section 93220 gives buyers in the ordinary course, purchasers who buy in good faith from a seller regularly dealing in such goods, limited protection when purchasing from licensed dealers. You take free of security interests created by that specific dealer. But the protection stops there. It does not strip off interests created by prior owners down the chain. And in consumer-to-consumer transactions, the garage sale exception under Section 9-320B, the safe harbor collapses entirely if the secured party previously noted its lien on the certificate of title, which it almost always has. The protection exists on paper. It rarely exists in your driveway when the recovery agent arrives with a court order and a spare set of keys. There are ways to reduce this risk. A buyer who follows the standard pre-purchase protocol typically begins by running the vehicle identification number through an approved NMVTIS provider before meeting the seller. Cross-checking with the National Insurance Crime Bureau's VIN check and a private history registry can flag active liens, unrecovered theft reports, and washed brands. Inspecting the physical title certificate in person comes next. Official state security watermarks matter. The seller's government-issued identification must match the owner name printed on the front. A title-stamped duplicate should be treated as radioactive. If an active lien exists, experienced buyers obtain an official written loan payoff letter from the lien holder and issue payment directly to the financial institution, rather than handing cash to the seller. They receive an executed lien release before releasing any remaining funds. A comprehensive bill of sale should include full legal names, the VIN, the purchase price, and explicit language affirming that the vehicle is free of all security interests, mechanics liens, tax claims, and municipal violations. Finally, completing the transfer jointly at a DMV office allows the clerk to perform a real-time database query for administrative holds. Filing a statutory notice of release of liability immediately after transfer creates a paper trail that shifts responsibility for subsequent violations. These steps won't make a buyer invincible, but they shift the odds. Because in the used car market, the paperwork doesn't just document the sale. It is the only barrier between you and a stranger with a court order. One last question before you leave. When you pulled into your driveway this morning, how many cameras recorded your license plate without your permission? Subscribe if you've made it this far. You clearly care about the legal machinery running behind ordinary life. Next time, we're looking at the security camera your neighbor aimed over your fence, and why, under the right conditions, that single lens becomes an illegal privacy tort that can put thousands of dollars in damages on their doorstep. If you have a backyard, a window, or a property line, that story is about you. You won't want to miss that one.